Well, thank you very much for that gracious introduction. And I am John Martin, and today we're going to be talking with your family about your estate planning. I did actually hear a joke that, well, they just want to hear about how much they're going to get, don't they? Well, we're actually not going to be talking about it from that angle, although I'm sure the thought has crossed our mind, but rather having constructive conversations that can minimize conflict, and allow for transparency that the estate plan has been done so you can create peace of mind for your family members and for yourself. And knowing that there will be less conflict, I think can create that peace of mind. So a little bit about myself. I've already received that gracious introduction. I am just a few blocks away. And what I do in estate planning is help families, help them with their plan with their loved ones, to transfer wealth, to plan for incapacity, and also to plan for protecting that wealth after it's been transferred to loved ones. So here's some questions that maybe you've asked yourself, maybe you haven't, but I want to guide us through the process of asking these questions this morning because I think it'll frame the subject matter and help us to understand what is good communication with your family members and loved ones. Have you decided not to share details about your estate planning with your family members for some particular reason, right? What reasons were those? Why did you decide not to do it? Just think about that. Do you know for a fact that your estate planning documents can be found in the event of your incapacity or death? Have you thought about that? Do you know for a fact that your agents and trustees, you know who those are, we'll talk about them in just a little bit, agents and trustees, will be available and willing to serve in case you are incapacitated or deceased? Incapacity means you just don't have the ability to manage your affairs anymore, passed away. I think that goes without saying. Death and taxes, two things that we can't avoid in life, right? Do you have confidence that your estate plan will not be contested or lead to conflict? Do you have that confidence? Yeah, a lot of you might be thinking, yes, and that's great, that's wonderful. A lot of you might have that sneaking suspicion that there are some things in there, maybe some items that somebody wants that another person also wants. Maybe a person who's been designated and it's going to be a surprise to them or to others. Maybe the values. So we want to ask ourselves these questions. As we think about the questions, it's also good to step back and say, well, what are we talking about in general? Maybe this goes without saying. When I was invited here, I was told pretty much everybody has an estate plan, which I think is great. But often we'll think about our plan like it's just a set of documents that you put somewhere. It's just the document itself. And of course, there is a document that's the estate plan. That's literally true. But ultimately, though, there's something above those documents, which those questions we were asking, right, are actually intimately linked to. So those questions about how you talk to your family members about your estate planning are actually intimately linked to what estate planning is about in the first place, which is maintaining control of your property and of your assets while you're alive, and as long as you're able to, ensuring your wishes are carried out if you become incapacitated, providing for loved ones after your death in the way you choose, and minimizing taxes, fees, court involvement wherever possible. Even as I did that, I went through that definition. You can kind of see, you can kind of connect how those questions that are related to talking to your family members actually play into what estate planning is. And that's not even a document, right? That's just what we're trying to do, what we're trying to accomplish. The ultimate goal, the ultimate end of estate planning is to make sure you can control your property, that your wishes will be carried out. If you become incapacitated, that you're providing for your loved ones and that you're avoiding cost. And of course, you can also think of it from a different angle as incapacity planning, wealth transfer planning, and beneficiary protection, protecting your assets, your legacies, your values. And why does this involvement with your loved ones matter? Why is it important? Well, if you can think about the cause of stress, have you ever been stressed out about something? It's kind of like a joke, right? Of course, every single day we have stresses. What causes your stress? What causes you to be uncertain and anxious about something in the future, right? For me personally, it's not knowing what's going to happen next, right? If I knew exactly what was going to happen in the future, right? If I knew exactly when somebody was going to walk through the door, I could prepare dinner for them. I could know exactly when, and I'm going to be less stressed out, right? But if I don't know what's going to happen next, it causes me anxiety. It causes me stress because I got to prepare for these things that could happen or maybe they won't. It's the same thing with estate planning for yourself and for your family members. If people don't know what's going to happen next, then that can create a lot of stress. Put yourself in the shoes of a loved one, right? A child of yours, maybe, and they don't know whether you did your estate planning, right? And you're here in Channing House, and they're wondering, did mom or dad actually go to an attorney? Did they do anything? And that they might have kept their mouth shut, or maybe they just blabbed and they said, go to get this all done. But either way, the uncertainty of just knowing that you've done something for a loved one actually can cause a lot of stress. And stress can lead people to make decisions that maybe are wrong decisions, right? And then it can help to communicate to also avoid what happens after stress, which is dispute, misunderstanding, conflict. So stress, uncertainty, right, can actually lead to conflict. And I will give some examples about this. I had a client who was named a co-trustee with his brother, and his mother passed away. And there was a plan that his brother understood that the mother had about the home, about him living in the home and staying there and being able to be there rent-free. And he, my client, did not have that understanding at all. His mother had never said that. There was nothing in the trust. But his brother said, well, everybody knows this. Everybody understands this. Everybody is aware. And so unfortunately, that led to them ultimately losing trust over all these other areas, like going to the bank and setting up title correctly, paying bills, dealing with when to sell other assets. And unfortunately, they ended up going to court. So miscommunication, misunderstanding over what mother's intention was actually led to stress, led to uncertainty, led to distrust, and ultimately led to litigation dispute. Good communication can strengthen trust. It can strengthen relationship. Have you ever spoken with somebody and you could just tell they were so straightforward. They didn't use a lot of words to cover over the subject. They just said exactly what they meant. And it builds trust, right? Imagine hearing something really clear from your loved one about who they want as trustee. And it's their statement of intent, and that's it, right? But it's said with love, it's said with transparency. That kind of good communication can build trust and build understanding across many generations. Here's a question for you. Who would know if there are suspect transactions in your account currently? Who would know? You've got a bank account, right? To pay your bills. Is there anybody who would be aware if something was going wrong in your account? Have you ever thought about that? If there was somebody taking money out, if somebody were talking you into some kind of transaction, right? Is there anybody who would be able to look into it and ask the question, like an advisor, a friend, or your successor trustee, or your family? Do you have any safeguards in place? Communication is related to this too, to preventing things from happening like financial abuse. What other benefits of early communication, and how can you implement these benefits? How can you actually enjoy those benefits? Consider involving your family members, your loved one, maybe it's children, in what I like to call a priceless conversation. Why priceless? Because the joke is, oh, they just want to hear about how much they're getting. The conversation doesn't need to be about that at all. It can be about orienting them towards the awareness that there is a plan, what you've done, that you've made decisions. Maybe you even don't talk about who's getting what and when, right? But just letting them know you made decisions. You wrote something down. You have a plan, that you've thought about them. You did something. That's a priceless conversation. It's not about what they're getting. It's not about the dollar amount necessarily, although you could say that, but it doesn't have to be. Consider adding your children to meetings with your advisors, your CPA, your financial planner, or other advisors. Why? There's a knowledge transfer that's taking place. There's trust that's growing. There's legacy that's actually being transferred through those relationships. The wisdom that you've been able to partake of through these advisory relationships is actually transferring through those joint meetings to your children. Consider talking with children about your wishes on the disposition of tangible personal property. You know, I do estate administration and trust administration. Do you want to know when disputes start? When they start, right? They start when you're dividing the stuff, the physical things. Why? I don't know. There's some sort of significance. It's, I think, a psychological thing, but it's emotional. Your loved one has passed. You're in the home. You're there with your sibling for the first time, maybe in your life, right? Depending on how old you are relative to your sibling. You don't have your parent there helping you as the umpire for your disputes. You know, I have two siblings. I speak with my siblings one-on-one. We're really nice to each other because we know, even if my mom's not in the room, we know she's a phone call away, right? So she's like an invisible umpire. What if mom's not in the room? And now you're dividing the stuff, and there's this physical significance to this stuff. There's an emotional attachment, and suddenly you don't have the umpire. Disputes can start. And sometimes they're not even in the room, right? Because they say, well, I don't even trust you enough to get into the room. Or, hey, I went to the house. I don't see where the earrings are. You must have taken them, right? You must have taken them because I don't see the earrings. So consider that you can actually head these off by having really good joint communication with your family member. Know what's important. So you've got these documents. We talked about how estate planning is not just a set of documents. Because if you're just focused on, I did it, I checked the box, I wrote the document, I put it away in my file, you might not know why it's important. And then you don't know what you're talking about with your children when you're talking about your estate planning. A power of attorney is important for very practical reasons. Because if you're no longer able to take Social Security benefits or take a minimum distribution from your retirement plan or deal with reward benefits for your credit card, only your power of attorney can do that for you. So knowing where that document is could mean the difference between paying a penalty for failure to take your minimum distribution on a retirement plan versus having no penalty, just having that conversation so that somebody knows where the power of attorney is and they know that they're checking in on you and they're seeing, okay, you're not communicating with your advisor anymore. I need to step into this role. Some coordination and education can avoid missing those deadlines to begin with. Saying, this is why I did this. I did this because, yes, most of my assets are in the trust, but there's going to be this really important point where I'm going to need all these deadlines to be met. So you knowing that and then being able to educate your family members on that, so important. Know why your healthcare directive is important. A lot of people are just thinking about the extreme things that the healthcare directive handles. Like, okay, this is, some people even equate it to the DNR. It's not a DNR. It's a directive that appoints some person in the future to make decisions for you for healthcare. But even more than that, it actually deals with things like burial versus cremation or organ donations. Did you know that people can fight over these things? I have had actually a client who was sued by her sibling over a burial versus cremation issue. And actually, it tore the whole family apart that they're fighting over what mom wanted. I had another case where I had a widow and she didn't know whether her husband wanted to be buried or cremated. And actually, she froze. She froze and she couldn't make any decision because she was so caught up with, I don't know what his wish was. Now, some people are like, well, this is so simple, right? But do your family members know how simple it is for you? Do they know how simple your thought process is? Putting something down, great. Talking to your loved ones about it, knowing why the document is important, right? Then can lead to the understanding of why you're talking about it with these family members. Avoiding probate is more than just creating your trust. It's also about making sure the assets are actually in the trust. So when you start talking with your family members, your loved ones, then you can miss some of these problems before they happen. Because maybe they'll say, Mom, did you realize that you don't have the life insurance going to your trust? Or did you realize you don't have the family business actually held in the trust? Maybe you never thought about it before. But then having that conversation can lead to those solutions being presented. Why is the HIPAA authorization important? This one actually is way more important than people realize. You know, we have very strict healthcare privacy laws in this country and in this state, very strict. So you can't just waltz into a doctor's office as a child and say, give me a letter saying my mom or dad is incapacitated. Did you know that? You can't just walk into a doctor's office and ask for that letter because your healthcare information is protected. It's privileged information. Your doctors can't release it to your trustee or to your loved one. So having this gatekeeper document, a healthcare privacy waiver, a HIPAA authorization, is essential. But your children may not even know that you have it, or your loved one or your professional trustee that you've named might not know that you have that document. So having that conversation with them, letting them know where you're keeping it. And then this is one of those documents I would say maybe you should share this one, right? Or maybe you should have a system where the document can be retrieved if there's an emergency. So for all my clients, I have a cloud storage system and an emergency contact card. They're in a medical emergency. There's a web address, a phone number, and there's a link actually to get this HIPAA authorization and the healthcare directive so that the letter can be retrieved from the doctor and decisions can actually be made. Letters of wishes. Sometimes it's hard to actually say these things in writing to loved ones. But if you can put things down in writing, there's a benefit of that. You can explain why you made certain decisions. And here I just like to have a little caution, a word of caution, that we don't want to contradict what's actually in your trust or will. Be careful there. But explaining why you made a decision. And then you can actually go and change that letter over time. You can throw it out and you're not amending your trust, which is a nice benefit because then you don't have to pay your attorney more money, right? But a letter of wishes that shares what your hopes and dreams are, what your values are, who your advisors are, and what you're hoping your children or your other loved ones will understand about the plan and why you did what you did. So how do you time this conversation? How do you do it? Should you involve your children from the get-go, your loved ones during your planning meetings? I actually counsel caution with this. Let me tell you a story. I had a gentleman that said, I want to involve my family members in my planning. He had a great idea with that. He said, let's bring them in. And I want to tell them everything. I want to tell them who's trustee. I want to tell them healthcare directive, who's getting what, give them the balance sheet. And so I said, great, that's wonderful. It's wonderful to have good communication. And so the kids show up, but do you know who else showed up? It wasn't just the kids. It was their spouses. Have you ever, sat down at a Thanksgiving meal and you're like, who did my child marry? Right? They're saying something that's just crazy, right? But sometimes we love them more than our child. So I mean, just to give perspective, right? But I was in this meeting and I just thought, my client told me to tell everything, so that's what I'm going to do. And we went through what the trust said. We went through who the healthcare directive was. And I actually gave out a handout and it had a summary. So it said beneficiaries, child one, child two, 50-50. And it said who the trustee is. It said who the healthcare directive was. I thought, this is great. We're educating everybody. And everybody was happy. They smiled. We shook hands. They went home. And about a week later, my client called me and he said, John, this was awful. This is horrible. I had no idea that this was going to go so badly. And I said, what happened? I said, well, my daughter-in-law called up and said, why am I not in the trust? Why am I not in the trust? And so now I actually say, well, maybe we should leave the in-laws out of it. Yeah. And maybe we should be really careful about saying who's getting what, right? Because sometimes we think, oh, this is so normal. It's really normal to think 50-50. That's normal, right? But maybe somebody's going to bring that home and talk to their spouse, and they're going to say, wait a minute, why doesn't your dad have a plan for me if you die before? And I know you're thinking, well, that's crazy. What a ungrateful, But actually, a lot of people do have this thought. So maybe to help not even begin that thought, we just think, well, the goal of the communication is to put the children at ease, let them know where the document is, right? But it's not necessarily to give people expectations over how much money they're going to get or to create their retirement planning for them, right? Because then maybe we're creating some false expectations, right? That weren't what my client wanted to achieve. So food for thought, who to involve and how. By the way, I wanted to say one more thing about when this meeting would take place. I think that priceless conversation might take place after you've done the plan, and the reason for that is because you've had the opportunity to fulfill your wishes. You wrote down what you wanted, and now you're bringing in the family to share with them what it is. This is your wish. This is your, right? And if there's changes that happened, I would want you to talk to them before you name them as trustee, right? But that's a one-on-one conversation. And then later you're bringing them in to ensure that they're familiar. I think part of the planning may be a mistake. If they're there in the room while you're naming the trustee, I actually will ask them to leave the room anyway. If they're in my office, most attorneys will do that. So I think it is a mistake to have them in the room. Lots of misunderstanding, miscommunication, sometimes even the child speaking for their parent, right? So I think better to have that independence. And I think it also should happen upon major life events. So if you've done a move, if you had a new grandchild, and you're now planning to fund education of a grandchild, if you are changing things really significantly, maybe you have a new attorney relationship, maybe you're storing the documents in some new place. I think it's good then to have that additional conversation. And then I think it's good to involve, as I mentioned earlier, the CPA, the financial planner. Your financial planner, if they're earning their fee, should be having some kind of check-in with you each year, at least, right? Some kind of annual meeting where they go over your portfolio, your investments. If they're not doing that, well, you should ask for that, because that's part of what they do, right? They have a check-in with you about what you're doing. And you can bring your children to that meeting. You can bring your trustee to that meeting so that they know what's going on. But you can tell your financial planner, hey, for the portion where my child or my trustee is there, here's what I want you to talk about, right? So you don't need to go over all your balances. It can go into what would happen in an emergency, right? This is the number you would call. Hey, this is what I'm handling for your parent or for your sibling or your loved one. I'm handling the investments. Give me a call. And then it can also handle some education. Like, okay, retirement plans are going to work this way. And life insurance is going to work this way. Here's the number you can call. Here's how you would set up your inherited IRA account, or handle a rollover in the event that a spouse were to pass away. So here's another idea. This is what I actually recommend all my clients do. Everybody's using email these days, and emails that are important, you don't have to delete. You can actually keep them in your email box. Some people have files, or they organize their emails, or some people just keep it all in their inbox. I recommend that my clients write an email to all of the people who are part of the plan, right? The trustee, the healthcare agent. And I recommend that they tell those people where they're storing their documents, who is in what role, and what they should do in the event of an emergency, who to call, right? And maybe you send out another email if you change those things, right? So that the email doesn't get out of date. This can create peace of mind. You send it to multiple people, so at least one of them is not going to delete this email, right? This is a great fail-safe. I have a lot of people saying, I'm going to give a copy to the document to my loved one. It's okay. It's not like you made a mistake. But what if you want to change it? Then you've got to take those documents back, right? And replace them. What if you've given them to 3, 4, 5 people? You've got to take all those documents back. We've actually had the battle of the documents before, where there's different documents that say different things, and people are going off to the bank, and they're each trying to put their name on as trustee. So you got to be careful that you decide, am I going to send out this document? Well, what if you change it? Real world examples. I talked about the brothers. I also had an uncle who said, I'm going to keep it simple. I'm going to just create a transfer on death account. My niece and nephew are named, and they're going to split it. Turns out this was a bond account. The niece was so mad at her brother that she said, I'm not going to sign off on the bond split. I don't care if he doesn't get anything. I'm never going to sign off. We actually had to go to court and have the judge come up with a bond split proposal, sign off. It was ridiculous, and there's no probate code section that deals with that. So I had to tell the judge, well, I know this is not a fit for the law, but we need something, or else this account just stays around forever. It'll never go away. Some people will not sign off on receiving money because they hate their siblings so much. I know that sounds really weird, but this could have been something that communication would solve, talking with them, right? Talking and bringing them in, talking with your planner, talking with your financial advisor, asking your financial advisor, will this work? What if there's a dispute? What if there's a problem? Successes. I have actually seen wonderful things happen. I know that's hard to believe because you hear attorneys that are all talking about horror stories. Let me talk about some victories. I had a client who put together a plan. He named one of his children as trustee, but he actually really thought about all the tangibles. So he brought all of his kids in together, and he said, hey, I want you to tell me in advance, what you're thinking. And I'm not going to agree, but I want to know. And he put them all in the same room together, right? So it's not individually talking to one and then individually talking to the other. That's, I think, the beginning of misunderstanding, because then people are like, well, mom said, or dad said, I'm going to have this. But then the other child says, well, dad said I was going to have that too, right? But if you put them all in the same room, you document it, right? This family, and I also have a thing where when there's like 6 kids, it's like, well, one of them is going to be a bad apple, right? And it just takes one for it to kind of go haywire. It's kind of true, but not always, but I've seen that happen many times. And this was 6 kids, so I'm like, okay, something's going to go wrong. It didn't. They all got together. They went to the home. I actually had my client, the successor trustee, he said, it was actually really moving. We were there together. Everybody had this positive, like loving attitude. And we went and we just one afternoon, we divided up everything. And we just really felt like our dad's wishes were honored because we had that conversation. He kept us up to date. He documented everything. It really, really worked. I also had another victory. I had a client, she had a cancer diagnosis. It was kind of sudden, but her 3 kids were all in really different situations in life. So one of them was a elementary school teacher, and one of them was like a CEO of a tech company. And then, and that actually CEO was in this always in litigations, people being sued, sue her neighbors, sue all these people. She's always suing people. And then she had a 3rd child who was just, like more of a rank and file government worker. And so she said, what should I do? I'm going to name my 3 children who are all going to be co-trustees with each other. And I'm like, I would really recommend that you talk to them, bring them in, see what they think. And you know what? I had this happen. The elementary school teacher said, I'd really like to suggest that we have a third party, like uncle, your brother, do this trusteeship. And they all said, yeah, I think that'd be a great idea for uncle to handle this. And we named him, and everything went just fine. There was no litigation. There were no problems. The CEO was fine. She didn't sue anybody. And the daughter, she called me up, and the elementary school teacher said, thank you so much for facilitating that conversation that we had with mom. Because that was like, you go into this door, right? And everything changes. You ever made one of those decisions in life? Wow, that decision I made, really everything was completely different in my life because of that one decision. So imagine, being in litigation for years, right? Because there was one decision that went wrong. When should you do this? When should you do your estate plan? When should you have conversations with your family? We talked about that. It's actually a very brief period of time. It's this period before incapacity. I've actually been called in to clients who were passing away, and I was able to do a late estate plan. I've also been called in, and I haven't been able to do anything. I went there and I'm like, oh my gosh, there's no understanding. So make sure you do this early and often. All right. I hope that was really helpful for you. I hope there were some good ideas. I did want to open it up to questions. And I do understand there's a mic that's going to be passed around. So I'm happy to answer any questions. Remember, I'm not going to give specific legal advice, but interested in whatever questions you might have.
I have a Channing specific question I think I know the answer to, but my future is going to be, I'm going to stay in my apartment until I need to move to assisted living on a permanent basis. At that time, I'll have to give up my apartment. Some things I can take with me, but mostly my apartment goes away, my car goes away. And I might move from assisted living to skilled nursing, and then I might even be in hospice at the end. So are there any specific issues with that kind of movement and among living support?
Absolutely, right? Choosing the right caregivers, choosing your right health agent, documenting what your wishes are at each stage in a healthcare directive. You just created this roadmap for yourself. You've obviously given this a lot of thought. You could probably jot down everything you want right now at every stage. You could just put that in writing, and then you could go to your attorney and you could say, how can I integrate this into my plan? And then after you do that, just following that model that I told you, you're talking with your attorney, you're talking with your financial planner, you're talking with your CPA, then you can bring in your loved ones and you can have that priceless conversation where you say, hey, I have these documents, and you can share whatever you want. You don't have to share all the details. You can just let them know, I wrote this down, I have a plan, and that can create peace of mind for yourself and for your loved ones. Yep.
You mentioned having a personal letter that explained your reasoning, why you did this, why you did that, and so forth. And in our case, we'd also have a long, complicated document, trust document that's going on. Giving the letter, the short letter that gives the kind of plain Jane explanation of what we did and why, can that conflict with the long document that
right.
nobody would want to read?
Yes, yes. And actually that was a point that I made, was that you do actually have to be cautious when you write down that letter, because there can be litigation over whether that was an amendment to your trust. So a good rule of thumb is, okay, you had the attorney draw up the document. Maybe I'll just give you an example. So let's say you're equalizing for some gift that you made. Okay, so you gave a house to a child, and now you want to give a gift to a couple other children to equalize. But you kind of figure that well, the child put a bunch of blood, sweat, and tears into that home. So actually, they kind of paid for it themselves. This is a real life situation, actually. So then you're only going to give a couple $100,000 to each of these other kids, right? Now, let's say you wrote a letter and you said, well, I only made it a couple $100,000 to each of these other kids because I know that my daughter put at least $750,000 into the home. So therefore, I'm not equalizing to the fair market. Do you see how that's a problem? Because now the kids can say, well, did she put $750,000 into the home? And then they could actually litigate that. They could say, well, I want to go in and get all the financial records and see whether she actually did that. Well, that's actually a mistake to explain too much, because if you explain in a way that's actually wrong, right, and it actually didn't happen. So I actually, you want to, in some cases, you're not going to want to be precise, right? You're going to instead want to use more language like, I love you all. And, I decided to do some equalization. I would ask you all to honor our choices, right? So you're not saying, well, it's because of this specific number and that, because then people can go in and they can actually slice and dice that and create a lawsuit. Unfortunately, that's the world we live in, right? Got to be a little careful. And you can always run it by your attorney to make sure it's not contradicting the trust. That's actually a good idea to keep those letters in the attorney's file too, right? Because how do you know it's going to be found?
What was most helpful for me was, because I have two sons. I've given one son who lives here some of the papers, not all of them, but contacts. Haven't taken him to meet the lawyer. I've had these plans for a long time, but it was very helpful to know not to give him too many pieces of old paper.
Yeah.
But whatever I do, each son should have the same stuff. I'm the same information.
Right. I mean, there's exceptions to that, obviously. But I do think that giving too much can potentially cause problems. So good comment. Yeah.
I wanted to share an experience that we had that relates to one of the things you were talking about. When my wife and I were moving to Channing House and knew that there were a lot of things that we weren't going to be bringing, but also some things that we are some art and other things we don't have hugely expensive, but things that have a lot of nostalgic value for our children and grandchildren. And so at a Christmas time before we moved, we handed everybody a sheet of paper and we asked them to walk around the house and to list everything they would like to get eventually, if they had a choice, and to rank order them 1, 2, and 3. So that then we got these lists, and I was surprised at how many things the kids and grandkids wanted, actually. And then I was able to make a list then of all the things that will be distributed and to whom. And then I shared that list with everybody, so everybody knows ahead of time who's going to get what of this picture or that thing or something,
That is wonderful.
And it was a great experience, but it's exactly the kind of thing you were saying. It's how to avoid the stuff issue.
That is so good. That is a huge act of love. It's actually a hard thing to do. Wasn't it difficult? It was a lot of organization. It took time.
Yeah, it did.
Right? But imagine just the understanding now that your children will have. That's, I think, very meaningful that they had that experience. Right? Go ahead.
Yeah, and it's an emotional experience for them, I've discovered in talking, because they don't want to talk about our dying, They don't want to talk about death. And so, let's not talk about that. And yet, for my kids and grandkids, I think it's been very beneficial.
Good.
Maybe you can produce a story that involves siblings who get along very, very well. And one of them is a top-notch business person and really understands the legalities and the complications that the surviving parent has to deal with. And the other siblings know this and appreciate it. And what do you think of that? With one child of 3, let's say, who can take over
Hmm.
at the final time.
Okay, let's just unpack that. You're saying that there's 3 children and one of them seems to get it a little bit more, what mom's
lot.
situation is.
A lot more.
Right. Well, I would just step back a little bit. And I think what your question is dealing with is choice of trustee, choice of fiduciary. And you're asking which child, right? And you kept it very open-ended and hypothetical, which I think is great. So when I counsel clients on that, I encourage them to list all the things they're looking for in a trustee, right? Somebody who's close by, maybe, that can help. I mean, sometimes there's people who are further afield, but being close can really help. Like, let's say you're incapacitated, going by the house, right? Selling things, dealing with tangibles, being close by can help. Available time. Some people work 100 hours a week. So having some availability, their honesty, if you know that somebody cheated on their taxes all the time. And some people are like, well, I wouldn't trust somebody who didn't cheat on their taxes, but that's a different story. But, somebody who will get along with others, right? Because do you have a very competitive child that really kind of, and sometimes there's also the silent child that like will be rolled over by that really successful other child, right? Like they won't put in their word. They won't say something. They're just kind of quiet at the table, right? And maybe this one child will basically be just making all these decisions. So you've got to be thinking about all these different factors. Now, it could be the right decision to name that responsible, local, available child. It could be the worst decision, right? Because if it's somebody who's going to just dominate everything and control everything, right? And be a big boss, maybe it will actually cause disunity. Sometimes you're looking at going outside your family, right? I mean, I gave the example of 3 kids and I said, brother. Some people are worried. They're like, well, my brother's older than me. So why would I choose my brother? And I always say, well, hey, you're going to have more than one person that you name. You're going to have successor trustees. This is the person who would be good today, right? In the next few years, 2 to 3 years, they're going to be a great choice of trustee. You might choose somebody different thinking about that. It's a very big mistake that people assume, right? They assume they're going to live to a certain point. They assume they're going to have capacity until a certain point, and then they're going to lose it, right? Or then they're going to pass. You never know. So choose the person who is most appropriate today. Good question. Very good question.
I have a question too then. Would you discuss fiduciaries? Because sometimes you turn to that kind of alternative.
Yeah, and you notice I didn't mention corporate, like bank fiduciaries. People are using bank fiduciaries a lot less than they used to because a lot of times banks are saying no.
Not bank fiduciaries, but other fiduciaries.
Right. I'm leading into that through the context of, hey, the third party used to be the bank, but now there's this new profession, which is California licensed professional fiduciary. And they take an exam. They have all kinds of different levels of experience. Some of them are former financial planners, former CPAs. Some of them were specialized in special needs. Some of them work in large offices. Some of them work in small offices. I work with a lot of professional fiduciaries. These are individuals that for a living manage people's trusts. And they're really going to vary. There's going to be great ones. There's going to be ones you want to avoid. So that can be a choice that people make. Instead of having a family member, they go to a professional. But I would just say, go and get a comfort level with that person. Interview them. Go to their office. Ask about their fees. Ask about where they have their most clients. What range of estate? Is it clients that have everything in a house and a retirement plan? Or is it only clients that have 10 million in investments? What kind of clients do they specialize with? Make sure you're a fit, make sure they're available and they can help you. Yep, and then make sure they can get your trust and that they're keeping in touch with you so that they know when they're supposed to swing into action. Great question.